For orders, review petition 64.
I am there, Lordship. I am before Lordship on VC. If Lordship would be pleased to accommodate me and Ladyship on VC.
Yes. Lordship. May it please your Lordship. On behalf of the respondent, your Lordship, you are entering appearance for the first time. Lordship, what I would like to bring to the notice of your Lordship is that on 31st, the contempt petition has been fixed. Therefore, this may come up together along with that matter. Can be heard together.
I have something to place for Lordship and Ladyship's consideration.
Sir, you will have to implement it.
I'm sorry, I can't hear Lordship, ma'am.
Okay. Can you hear us now?
So,
Hear us now? No.
yes, Lordship. If I may just share with you, Lordship, this is the first one where Lordship has issued notice from the state's perspective. 5 other reviews are pending, which will be coming up very shortly before Lordship. My humble submission is you have dealt with 6 services, and all the review petitions that the state has sought are limited only to para 67 and 68. Additionally, Lordship may wish to consider that today as item 40, of course, Lordship, Ladyship will not be part of that bench, but there is another review petition that has come from the side of one of the private parties, Pallavi Sharma, that will be coming up, Lordship, also. So I was wondering if all reviews can be taken up simultaneously on some date, then Lordship, that might be perhaps subject to Lordship's consideration, more convenient.
The respondent is also suggesting, the respondent's counsel, that the matters are otherwise fixed on 31st.
But 31st is the contempt, Lordship. I would respectfully say that the contempt is a separate jurisdiction, review is separate. I think there won't be overlapping points because our point is only on the statutory.
This is the bench. The constitution of the bench is.
I see. Yes, of course. We can keep it separately. I'm grateful for that, Lordship.
But this time, the senior counsel, video conferencing mode, assisted by Mr. Dina,
and Lordship, Mr. A. Roy and Miss N. Menon. I'm so grateful.
Mr. A. Roy and N. Menon will possibly present. As well as Mr.
T. Kashyap, your Lordship.
T. Kashyap.
T. Kashyap. T. Kashyap. T for
Tripura.
Tripura.
The T. Kashyap and counsel for the respondent. And John Fair, Midland counsel, senior counsel for the petitioner and the counsel for the respondent. List the matter of 31/7/2020.
So grateful. Deeply obliged, Lordship, Ladyship.
Can I get to review the convention?
Let be over. There's an urgent writ petition, my lord, which has been already filed Saturday. Can it be taken up tomorrow, my lord?
I have heard item number 3, my lord. I was out of station, my lord. I came back yesterday night, my lord. I'm praying for the adjournment for the day only, my lord. Any day in the next week, my lord.
Which one? Which
Item number 3, my lord. 19, my lord, I know, my lord. Any day in the next week. First week.
So next week. Yes. Okay, both sides are represented on the pair made by one counsel for the petitioner. List on. (29/8, 29/7/2026).
My lord. Completely.
Let's go.
Also, I'd like to mention item number 42, my lord. And maybe I mentioned on behalf of Mr. N. Khatoni, respondent's counsel. Some personal difficulty, my lord, we will not be able to come to the court today, my lord. Other side concern that will be taken up. Matter will be taken up either on Friday or Thursday, my lord.
So it goes next week. 29th, same day. Which is represented on the pair made by one counsel for the respondents. The questions which are today. List on 29/7/2026.
Lordship, I have beg to mention item number 2, Lordship. Lordship, kindly adjourn the matter for today.
19 matter.
My senior is suffering for illness.
It's okay. Let the matter be called, then you will keep it.
Lordship, I beg to mention item number 16 and 32.
Item,
Item number 16 and also 32. Fairness senior counsel, he is out of session.
16 you are allowed, but 32 you have to renew the prayer when the matter is called. The review petition. Item 16, which is a representative on the prayer made by the this storm, it goes to 29th civil. Yeah, other item 32, please renew the prayer when the matter is called.
Immediately, Your Lordship. Lordship, I beg to mention for item number 26 and 28.
26 and
28.
28. I'm sorry, 29.
Item number 10, on the behalf of Jai Hussain. He could not appear.
Item 10, you have to wait. This is detailed matter. Wait till the matter is called.
For motion, item 1.
May I please, Your Lordship? Praying for 1 week time, Your Lordship, because brief was missing from my chamber. Just today morning only I found the brief, Your Lordship. So praying for 1 week's time, Your Lordship.
Documents are not exhibited during the. Here, giving the report. The lawyer himself required an NRC hearing.
Lordship,
The advocate himself required an NRC hearing. We have plated, there's no document.
no document, that's what I was. Evidence on affidavit, Lordship?
No document accredited.
Yes.
It mentions reference documents in the W.
I checked it there.
The
I checked the record, Lordship, it was not there. In the absence of documents, difficult to use the case, Lordship. No, she was not.
fact that there is no document.
No, she couldn't. The documents produced are in the name of Renuka Biswas, not Mayavadi.
The
Documents produced, now she says her name is Renuka, not Mayavadi. Lordship on Wednesday, Lordship will decide for that.
Item 2 for motion.
May I please, Lordship? Lordship, kindly timing the matter for today, Lordship. My senior is suffering from some illness, Lordship. His mother also died two weeks before. His mother also died two weeks before.
You should notice and take it up for 2 weeks.
Yes, sir.
It's better. Your name?
Tuesday.
You said. Pursuant to order passed earlier, the records of the tribunal is received, which requires examination. Issue notice, returnable on, give a date after 2 weeks. Returnable on. without requiring instruction. This is the matter in the admission column on so and so.
Item 4.
On
17th of August. Item 5.
My pleasure. To be in this case, lordship, the petitioner is declared as a coroner lordship, expert as judgment is their lordship. And we will find lordship page number 61, the judgment of the expert order passed by the tribunal Gauhati lordship. 61 type copy lordship. No notice was served to him lordship, and subsequently he was decided as expert lordship. But actually he is the permanent resident from Nagaon lordship, Nagaon district lordship, Morigaon.
We are fixing all such expiry orders that federal bodies.
Yes, Lordship.
All these issues where the pursuant to Supreme Court judgment,
I read it this morning.
all these matters where the expiry opinions were passed, we are fixing it on 3rd of August.
3rd of August, Lordship.
So they were presented in pursuant to order passed again, they got the evidence received, cross examination. The issue notice returnable on 3/8/2026 without requiring an answer. Next. In this case, the petitioner suffered an ex parte opinion. Even the matters have been taken up on the
This is ex parte orders of 2009.
9 and there is no service. Okay. So 2 pages down. Don't bother with that. It's a comfort down below. You can ask your.
The Lordship, I go through the records. This petitioner at some point of time, he must have been in Gauhati because the reference was there. So he
That's
must have
okay.
shifted his residence.
57 report, then you'll understand. The back page. No, the summons is there in the back page.
Yes, Lord.
No, down below. Down below. Let the process service report.
Yes, sir. Keep it was here.
Back page.
Some cases we also having legal.
The customer's report says
Yes, Lord.
that the man was not found at the given address.
Yes,
And then he asked people around and nobody could say because he has left.
yes, yes.
And then the notice was not served by return.
That's all.
The 355F was not complied with.
Lordship, will you take it upon her lordship?
There's no point if the service report is not there, we have to send it back, otherwise.
Lordship, today or on her lordship? Yes,
No
Lord.
point in it pending.
Opinion is of 2009, lordship, of first report in 19 and it's almost 26 now. Yes, lordship, page 61.
After 10 minutes.
He has been very late. He has not explained the delay, lordship. Each case is different from the other one. And a delay of,
Not know. He will come only when he comes to know about it.
Exactly. Delay to continue, he doesn't have the case also.
But is there of counsel for the position? And so for the respondents. Next one. By filing this petition in Article 226 of the Constitution of India, the petitioner has sent the ex parte opinion dated 7/11/2009, asked by the learned member from a foreigner's family in Gauhati, page 63. In case numbers also, police inquiry numbers also, by which the petitioner is declared to be a foreigner of post 25 in 1971. Next one. The learned Education for the Border and Active Matters has opposed the petition on the ground of inordinate delay and assist in opposing this report. We sell the opinion, ex parte opinion dated 7/11/2009 on the ground that this petition was filed on 25/11/2019. After around 10 years. After 10 years. Next one. On the perusal of the records. It is seen from the process service report which was returned by the concerned Board of Police in Gauhati on 17/4/2000. Four 2009. Police personnel was assigned to serve and return the process. Did not find the petitioner at the address given in the notice, and people in the neighborhood did not know about the petitioner, and accordingly, or because he was not found at the given address, the process was returned. Accordingly, the court finds that there was no compliance of order 3(5) within bracket F of the foreigners educated travelers to order for 1964. Next paragraph. On account of delay and lashes, for which the learned standing for the FT and order matters is raised for objection, it is noticed that the petitioner has made a statement in paragraph 11 of the petition that this only when his name was not reflected in the draft NRC. He went to the office of the NRC to make inquiry and came to know about the ex parte opinion passed about 10 years back. And accordingly, the present petition was filed. Next part. Be that as it may, as the process was not served in compliance with the provision of order 3 within bracket 5 within bracket F of the foreigners within bracket tribunals was order for 1964. Despite long delay in asserting the ex parte opinion, the service not made in accordance with the service of notice not which is not made in accordance with law has vitiated the impugned opinion. Moreover, in paragraph 1 of the impugned opinion, it has been mentioned that as per the report of the in the notice by the serving personnel, the petitioner had left the place for unknown destination. Accordingly, the learned tribunal had decided to proceed with the matter ex parte without recording its satisfaction that the notice was duly served. Accordingly, the impugned opinion dated 7/11/2009, case 63 is hereby set aside. Next one. Petitioner, namely so-and-so, was duly represented by his learned counsel, directed to appear before the foreigners tribunal in the after time limit of 24/8/2026, and on the said date, the petitioner shall file a written statement of defense and also annex thereto all the documents on which he intends to rely on. Thereafter, the learned tribunal shall make an endeavor to dispose of the matter as far as practical, within the time permissible under Order 3 within bracket 14 of the foreigners within bracket travelers of the good order of 1964. Next paragraph. The registry shall send back the records, the expeditions to the learned tribunal. Next paragraph. This is allowed as an order of remand as indicated above.
My lord, one small prayer, lordship, can it be transferred to Nagaon from Gauhati to Nagaon, lordship?
It is settled on.
Lordship. Very poor person, lordship. Very poor person, lordship, otherwise he will be paid.
Can be helped.
Deeply obliged, obliged. Obliged. Already settled, transfer, settled it already. Deeply obliged.
Item 6.
Kindly pass over a matter for time.
Take it up at 2 o'clock.
Item 7.
Lordship, my lord, in this case, my lord, Alceros call for Indimo's granted, my lord. No notice was issued, my lord. So, my lord, this is just my humble submission and net the notice is issued and the matter fixed for the admission hearing, my lord. Any date, my lord.
Pleasure represented. Pursuant to order passed earlier, the record of the transfer is received from our enterprise examination. Next one, issue notice returnable on Thursday. List the admission cover and date after 2 weeks.
Hello, Mr.
Item 8.
Passed over for a time being of fixed 2.
Item 9.
Sir, 19 any other day, my lord. 19? The date, my lord, already said 19, but I am out of state in 19. Any other date, my lord. Only 19, my lord, except 19. Any other date. Any other date. On 21 August.
Wait, please, your lordship. Lordship, the impugned order starts from page 50, your lordship. Here, your lordship, this year has been received, your lordship. Yes, thank you. Your lordship, this is a matter, your lordship, where a woman who is a resident of Bihar, your lordship, has been drawn under this proceeding, your lordship.
Lordship, can this matter be taken up some other day? I don't have a the brief, Lordship.
Yes, sir.
Lordship.
Give it a copy of it.
Lordship.
The notice later the belongs to a copy of the decree should be provided to Minister Kalibasa for the body and still matters within 2 days. List in the admission column and so on. So let's make a note, the next date when you make the submissions,
Lordship.
also get us the downloaded copy of the Bihar birth and deaths registration rules. Because this is a certificate of 2018,
Lordship.
declaring the date of birth in 1950.
Lordship, there is another certificate, permanent residency certificate. That also mentioned.
Birth certificate is more relevant.
Lordship.
21 August.
Certificate, we don't know whether it is admissible or not, the other certificate.
Lordship.
So we have copied.
They refer to as a transfer certificate.
Lordship. No, Your Lordship, there was a school transfer certificate that has been submitted, but the author of the certificate didn't appear.
Item 10.
My lord, I am appearing on the behalf of Jed Hassan. Like he could not appear because of waterlogging. I'm paying for the next date.
History the admission column on 20.
21 August.
Next week. Next week,
21 August.
next month. Okay.
Fine, due to date before.
My lord, I am requesting for the next week. Yes.
July. Item 11.
Is Verma?
Yes, Lordship.
You have the records?
No, Lordship. I had the petition.
Two separate opinion has been received in one petition. Look at it there. Page 23.
23, Lordship. Twenty-three is the prayer part, Lordship.
Okay, there was a common opinion.
Yes.
The opinion is a common opinion. Page 86. Now, a question call for the petition petitioners. The respondents are presented. Listen to out of custody, according to the travelers received from present examination. Notice to the level of also. You have to carry an steps to be taken. That is made clear that the petitioners remain absent for the next date of visiting from our advice office. Next list in the admission column also.
Item 12.
May I take my, I am on behalf of AFSN, my lord, due to some family emergency, my lord, they could not be here. My lord, in this case, my lord, notice not been issued, my lord, clearly.
Yeah, person to the court, the appearing on behalf of the as well as also for the response. Person to order pastally, the records of the tribunal is received, which requires examination. Additional notice, return of the logs also. List in the admission column answers.
21 of them.
Item 13.
Okay, good luck. Lordship, here the order is from, page 31, your lordship. This is an ex parte opinion, your lordship.
Yes.
Your lordship, the ground taken by the petitioner here is that he has never received a notice, to your lordship. I have also annexed, your lordship, report of the process server, your lordship. Page, your lordship, the vernacular, it starts from page 26, your lordship. And page 27, your lordship, it is respectfully submitted before this tribunal as per the address mentioned in the notice. I went to the given address and handed over the summons to the person but could not find her. Hence, the notice is handed over to other family members and it says the notice is returned to the honorable tribunal.
Yes. For the notice. Yes, sir.
Your lordship, the petitioner has been living in the same place, your lordship, since years, your lordship. Even he has voted in the, from the same place from the year 1971, your lordship. He stays there, your lordship. He is around 85 years of age as of now, your lordship.
But according to the server, the notice was served.
Yes.
Family members.
Lordship, I've mentioned it. Your Lordship, page 6, Your Lordship. Page 6, Your Lordship. There are 5, Your Lordship, I have mentioned. The petitioner begs to state that upon a reference being made by the respondent number 6 by police inquiry number so and so, a foreigner's proceeding being FT case number so and so was initiated against the petitioner before the learned foreigners tribunal. As the petitioner has not received any notice to the said proceeding or had any knowledge of the same, has not appeared before the foreigners tribunal, and consequently by impugn expertise order that so and so was declared a foreigner of post 1971 string, Your Lordship.
The ERO report is Muhammad Abdul Islam, and he has stated himself to be Salam.
Abdul Salam.
So he has to first clarify whether he is Abdul Salam or Abdul Islam, Lordship. He's relying on the ERO report of Abdul Islam. His petition is named differently, Lordship.
Your Lordship,
And it's a ERO report, it's a door-to-door enumeration done, Lordship. When the petitioner was asked for the documents, he could not produce any documents, so he was marked D in the year 2006, Lordship.
Your Lordship, the very fact that, Your Lordship, that my name has also not been written correctly, Your Lordship, I was not aware. Your Lordship, after I came to know that an expertise order is pending against me, Your Lordship, and the police is on the search for me, Your Lordship, I appeared before the tribunal. I approached this honorable court, Your Lordship. And if Your Lordship peruse the verification report, Your Lordship will find not just the name, Your Lordship, the entire report is, Your Lordship, empty, Your Lordship, blank, Your Lordship.
If no documents are.
Your Lordship, even the stream has not been mentioned, Your Lordship. Because its stream has been mentioned in that. A tick has been made in post 1978.
Notice the serve logic, no, not latka jari. Latka jari was the. Your lordship.
You are not following. It is. Exactly, that is what, I was also reading that. Yes, of course. Even time is trying to. গতিকে গাঁৱৰ উচিত 9জনমান থাকিলে সাক্ষাৎ বাসস্থানত গৈ নটিচ মাৰি যদি নটিচ Even I am not being able to do so. গতিকে
Well, Your Lordship, at that moment, someone, I don't remember who had translated 7 years before, Your Lordship. Your Lordship, now I'm also trying to read out, Your Lordship. I can only read notice Mari. I'm just getting that portion. Notice Mari.
notice.
Also, place of the matter.
According to the
English.
there's an additional detail issuing contract to the burden to the current office as after service well after the.
Latka jari. In English, the word latka jari is there.
Additional to the survey issuing, issuing for to the superintendent office,
Task.
task,
TSK.
after service by not present.
Border responsibility.
Superintendent of the SU, DTP, OCDT squared into sort of thing.
We have to witness a similarity. Practical new.
নিরঞ্জন বরগুনা নিরঞ্জন দত্ত সীমান্ত Yes, London.
If you address to different Bharat. Oh, if you have address, resident of Bharat, which part? I think so. No, he is the first. He composed the journal, he actually. You have to establish Islamness in
The Shah himself run transportability. And also for the respondents. Next. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so has the same. The party opinion dated 28/5/2012, passed by page 31. Passed by so-and-so. In case numbers P numbers so by which the petitioner was, by which he was declared to be a foreigner. No, he was declared to be a foreigner post 25 in 1971 speed. Next paragraph. The Learned Counsel for the Study Council for the FT and Border Matters has opposed the maintainability of the petition on the ground of inordinate delay and latches in issuing the said opinion. Next. On a perusal of the tribunal's reports, I can see that the notice is stated to have been served on the petitioner in a substituted manner. However, on a perusal of the process service report, due compliance of the provisions of order 3 within bracket 5 within bracket small f of the foreigners within bracket tribunals, bracket close order from 1964 is not found. Said provision requires notice to be served to be affixed at the outer door or some other conspicuous part of the house in which the proceeding ordinarily resides or last resided. the delay in issuing the impugn opinion would not be fatal. Accordingly, the court is inclined to subside the impugn opinion dated 28/5/2012, case 31. Next paragraph. The matter is remanded back to the said learned tribunal for further proceedings. Next, the petitioner is duly represented by his learned counsel, which shall render appeal before the said learned tribunal within the outer time limit of 24/8/2026. We shall produce a certified copy of the order, as well as Harry's legal statement of defense and file the documents in support of the defense. Next one. The learned tribunal shall have to make an endeavor to dispose of the reference within the time prescribed under Article 15 within the 15 of the ordinance within the tribunals, order for 1960. Basically, shall send back the reports to the said learned, which shall remit the reports expeditiously. Next, information stands allowed with the order of demand as indicated above. Next, there shall be no orders proposed. Just one more. As we have stated, the matters shall appear within 30 days, within the 28, or within 24/8. After that sentence is over, that is made clear that if the petitioner does not appear against within the time allowed, it would be open to the said learned tribunal to treat the matter, treat the petitioner as absent on call and proceeding inside the matter in accordance with law.
Obliged.
Item 14. Item 14.
Ms. Verma, Mr. Andy and Mr. Verma, view of this nature of orders which are coming. In view of this nature of orders which are coming, I think please meet me at the chamber at 1 o'clock after we rise.
Meet you, Lord. Your Lordship, impugn order first from page 15, Your Lordship. In this matter, Your Lordship, PCR has been received, Your Lordship.
This statement,
Your Lordship, you can find my written statement on page 36, Your Lordship. Your Lordship, voter list, in my name, Your Lordship. Your Lordship, the first voter list that has been exhibited before the tribunal in my name is of the year 1997, Your Lordship. And that Your Lordship will find on page 2930. 97. Lordship, the petitioners have been living in village Rajbaral since 1965 up to now, Your Lordship. In the year 1997, his age has been shown as 38, Your Lordship, but he has disputed it, Your Lordship, because as per his school certificate, as well his statement, Your Lordship, in the written statement, his birth year was 1965. So, going by that, his age ought to have been around 32, Your Lordship, in the year 97. Lordship, in those days, Your Lordship, the student used to go to the school, but their parents hardly visit the school or they hardly put any signature on the, most of them were illiterate, Your Lordship, in the year 1970s, Your Lordship. That is one reason, Your Lordship, which I is doing, Your Lordship. But in the deposition, Your Lordship, the DW3 deposed that the signature was that of the earlier headmaster, and he could recognize the signature. Your Lordship, the certificate Lordship, the certificate was not issued during the pendency of the case or when after the reference has been made. Your Lordship, it was issued back in the year 1983. School certificate. It was 13 years. Sure. It was a part of it. It was 1980 around 64. If you want to, ending of 2019, it was 50. It's the idea of you could recognize the show. Lordship. Lordship, the petitioner has exhibited the voter list of 1965, 71, and 77, 85 pertaining to his parents, Your Lordship. And his voter list, where his name appeared, Your Lordship, in the year 1997, Your Lordship. Your Lordship, the age shown in the voter list is 38, but going by the age, going by his by the age he has written in his written statement, Your Lordship, or his school certificate, it ought to have been around 32, 33, Your Lordship. Your Lordship, the voter lists were proved by DW2, Your Lordship. And Your Lordship, the school certificate, to prove the school certificate, Your Lordship, the DW3 appeared before the tribunal, Your Lordship, and because that, Your Lordship, that certificate has been issued from that school, and Your Lordship, it was issued by the earlier headmaster, Your Lordship. And all the voter lists, Your Lordship, will find that, Your Lordship, all the voter lists pertain from the same village, Your Lordship. That has not been activated. What? Lordship. Lordship. 1985. And 1997, Lordship. No, Your Lordship. Your Lordship, in the year 1985, Your Lordship, I was not eligible to vote, Your Lordship. Because at that time, Your Lordship, the minimum age required to vote was 21, Your Lordship. Your Lordship, my name ought to have appeared in the voter list of 1989, Your Lordship. But Your Lordship, that voter list was not exhibited before the tribunal, Your Lordship. The only voter list that has been exhibited is of the year 1997, Your Lordship. And with regard to linkage, Your Lordship, the only document, Your Lordship, which I have exhibited is the school certificate, Your Lordship. And that certificate was issued back in the year 1983, Your Lordship. Lordship, Lordship, the only ground, under which your Lordship, my, school certificate has been discarded, your Lordship, is that my, that signature of my guardian are not, cannot be found in the vacant space, your Lordship. Your Lordship, and your Lordship, my parents were really fit, your Lordship, and your Lordship, that's why your Lordship, they never, your Lordship, bothered to go and sign in the admission register, your Lordship. And your Lordship, with regard to your Lordship, any document, your Lordship, which was sought for the determination of my age, your Lordship, which has been mentioned, your Lordship, he has not deposed on the basis of which document or of which information the age of the said Ahmad Ali is recorded in the admission register, your Lordship. At that point of time, your Lordship, the age used to be recorded on the oral submission of the, your Lordship, parents or the student, your Lordship. There was, birth certificates were not available at that point of time, your Lordship. Your Lordship, his age, as on 1977, your Lordship, is around 10 years, 8 months, 11 days, your Lordship. Going by that, your Lordship, his birth year is somewhere in the year 1966-65, your Lordship. And that is the birth year, your Lordship, the petitioner has, your Lordship, submitted in his written statement, your Lordship. Your Lordship. Your Lordship, only the thing is, your Lordship, in the voter list of 1997, your Lordship, his birth here, going by his birth here, your Lordship, age, your Lordship, his birth here would be around in the year 1959, your Lordship. And your Lordship, in many voter lists, your Lordship, it is found that, your Lordship, there used to be discrepancy with regard to the age, your Lordship.
The age discrepancies has all been stated by the petitioner himself in the inquiry report before the school authorities, lordship, and then again in his written statement and the electoral roll. So, he cannot put the blame on anyone saying that the difference between his age has not been corrected, lordship. And there is no explanation as to why he does not have a voters list with his parents prior to 1997. His first voters list ought to have been there in the year 1989, lordship. 97, that this 10 years gap has not been explained, neither in the written statement. He has mentioned about his siblings, lordship. Written statement is all about the voters list of his parents, 65, 66, 70, and 85, lordship. But no mention about his siblings, whether they are there or they are not there, and his place of birth, lordship. That is at page 32. 32 to the written statement starts at page 32, lordship. 36.
it is only about the parents and about the, his parents also had three names, Lordship, and not a single independent witness to prove that the projected parents are the petitioner's parents, Lordship. Another thing, Lordship, his own name has three aliases, Ahmad Ali Ahmad, and there is one more, Muhammad Ahmed Ali. And it is his own self statement that they are all one and the same person, Lordship. Maybe because of the documents, he has tried to connect it to different names with the different documents. Evidence on affidavit, he has himself stated he is 53 years, Lordship. Lordship. Yes. 89. That is because, Lordship, that voter list may not be, it is not connected to his parents. It is a voters list only of him and his wife. Had that continuity been there, Lordship, it would have matched. And even the ERO, Lordship, at page 50, who has deposed before the tribunal, in his clause, he has said in the main list of 1971, the names are mentioned from serial 53 onwards. In the voters list of 1977, there is no seriality. None of the pages of the voters list contains the seal and signature of the electoral officer. It is not a fact that the voters list brought before me are not the genuine one. It's not a private document. Lordship, there is no explanation as to why he does not have a voters list with his parents or prior to 1997. The burden is on him to prove that he has the documents and to prove his citizenship, Lordship. Exhibit 5, which is relying on the school certificate, Lordship. My copy is not clear and legible, so I'm not able to just make my submissions on that, Lordship. School certificate in 83 subject. any one single document to show his linkage with his parents' lordship. That is not there. Not proved lordship.
Lordship, it has been proved, your lordship.
No, but not by the author lordship.
Your lordship, author retired by then, your lordship. It was a alternate, it was a site.
No, he did come, he recognized the signature. But Lord, I just want to check whether he brought the folio or not, lordship. Whether it was matched with the original receipt or not. Sorry. Lordship, there is a name discrepancy in the school certificate. Exhibit 5 at page 60, Lordship. Exhibit 5 is a school certificate issued by the headmaster so and so. In the said exhibit, the age of Muhammad Ahmad Ali is shown as 13 years, 8 months as on 1978. One Nazrul Haq, the headmaster of so and so 88, has appeared as witness who is examined at GW3. He has brought the admission register of the school containing admission of the students since the year 1977 to 80 and exhibited the same as A, and the page in which the name of Ahmad Ali is recorded as Exhibit A1 and the serial number of Ahmad Ali as Exhibit A2. So he has reposed in his cross that the column of full signature of father and the guardian has remained vacant. He has not deposed on the basis of which document or whose information the age of the said Ahmad Ali is recorded in the admission register. His own parents' names are missing in the register, lordship, which ought to have been verified. No, names also. Full signature.
Signature.
Yes. Lordship, I was submitting that the register ought to have had the names of the parents. If not the full signature, he says that the column of full signature of father and guardian has remained vacant. That means there is not even an initial in that. It is completely vacant. Nobody has signed to take that certificate. And further, it says he has not deposed on the basis of which document or whose information the age of said Ahmed Ali is recorded in the admission register. It may have been just a certificate procured from the school, lordship. Maybe he never went to that school. Because if the parents and the guardians' names are not there, and the person who has brought it, the in charge headmaster who brought it before the court, lordship, he has specifically stated that and a depose in his cross that the column of full signature of father and guardian has remained vacant. He has not deposed on the basis of which document or whose information the age of said Ahmed Ali is recorded in the admission register. This is relevant, lordship, though he has obtained it in the year 1983, which may be correct, lordship, but the headmaster has disclosed before the tribunal that he has no knowledge because he was not the author of the certificate. The author was the previous headmaster. He has just deposed that he knows the signature, that was of the previous headmaster. Apart from that, he has not stated that the,
Able to accept.
yes,
This is, will only be the officer who will come and depose.
but he is not the author, Lordship, so he has no knowledge of what is written there, contents.
Who is the headmaster?
He did not come. The other one came.
See what happens, if this person is not there.
So exactly, Lordship, that is why the present one has stated that he has no information on what basis the certificate was issued.
The headmaster who will come and depose. He is deemed to be the author. The reason is that the earlier headmaster,
He may have retired then.
if I want to go and correct my school certificate now, I passed out with 83.
It will be done on the basis of records, Lordship. And the records are such,
In 83, the headmaster is not there.
yes.
Then what happened?
So the presiding one, the present one who is there at that point of time, he will give the certificate on the basis of the records.
No, that is not his case. His case is that the certificate was issued in 83. So the 83 incumbent cannot come and.
No, he cannot come, but the register he brought, Lordship. He brought from 77 to 80. But the certificate is issued in 83. The register which the headmaster brought, it only showed that he was in that school. The register which issued the certificate, Lordship, what I am trying to place before the court is,
So yes, what is the admission register? What,
that he was in that school till he was 13 years of age. What I am trying to place before Lordship is the certificate which was issued. There is a folio. Every certificate has a school folio, Lordship. When they give the certificate, the numbers are there. That folio and that copy was not presented before the court. So on what basis that certificate was issued, that is not clear. Only he was at that school till during the period 77 to 80. That is that register was placed before the tribunal. And in 1977, as on duty, there's 1977. Very interesting. The tribunal has rightly pointed out, Lordship, that different ages by the petitioner has been given by him.
Your Lordship, may I just point out,
see, there's a difference.
Your Lordship, just there is discrepancy in the order itself, Your Lordship. If Your Lordship move on to page 60, on the second paragraph, it says, Your Lordship, the learned member says, Your Lordship, his age as on 1978 is 13 years. Again, after two paragraphs, he goes on to say his age is recorded as 10 years, 8 months, 6 days, as on the date of.
That's. It's a completely wrong question asked. Wrong answer given. This is certificate.
Yes,
It
Lordship.
contains the date. Correct.
Yes, Lordship.
Now, there is another flag. Correct.
Admission
Now, this
register.
is the admission register.
Yes, Lordship.
So, and the question is asked to the witness, is that the on which date exhibit 5 was issued is not mentioned. They are showing, they are showing to the witness exhibit A and then asking what is the date of issue. Naturally, it is not be there. Correct. If, in the evidence, he gives the exhibit and the exhibit number, and that is, the document is marked as exhibit. Admission register is marked as exhibit.
Exhibit A1.
Yes.
Yes.
So therefore, naturally in exhibit, there is no seal or end signature. The date of birth column is blank,
Blank.
but the date of date is not blank. On two places it is written, page 1 and page 2, the second last serial. You see what is written is 10-8, 10-8-6 in the first column. 10-8-6. Correct. Second last entry.
Yes, Lordship.
Second last entry. So first page, second last entry. We'll resume as two.
I've checked that.
Correct.
69 something.
What is written?
Muhammad Ahmed Ali, 3477. Date of admission.
No, the date of birth is also there. The first page. First page that, yes, this page.
This is the register.
No. That is the first page. Yes. Yes. Second last. Second last entry, I think. First column.
Mohammed Ali Lordship.
From below, second last.
Yeah, Lordship. Date of admission is Lordship
Date of
34/1977. Date of pupils Muhammad Ahmed Ali.
Ahmed Ali.
Yes.
Father's name
Janab.
Muhammad Janab Ali.
And then continue in the next page. And then there is an overwriting, but
Okay.
it's there.
Yes, sir.
Yes.
The second last is Lordship with 30/110.
Not 8 to 3477.
77.
It's over.
Overwriting is there. Lordship.
Photo is there, but it's
That is
it's
there.
there. So that is it and the wrong question. We continue. We have a meeting right now.
It is part of Lordship.
So we'll take it up.
Well, my lord, if type permit, item 25, is he's in jail, man. Never taken up.
Yes.
Lordship, we went through the records. Lordship had shown about the register and I sent back the records. Lordship, I've gone through it.
Ah.
Yes, and the date of birth, that overwriting.
In fact, we see this date of issue because read by the tribunal to
Lordship, this is not audible, Lordship.
you're getting it now?
Little bit more
Seven.
would be better, Lordship.
You're getting it now? You're getting the sound now?
Yes, Lordship.
Now, this school register, which this certificate, exhibit 5, it does contain the date of issue. That was read by the tribunal to be not there.
No. Tribunal has said, Lordship, page 60, Lordship. That he has stated that the age of Ahmad Ali is recorded as 10 years, 8 months, 6 days as on the date of his admission. That is on 30/4/1977.
Yes.
It is there, Lordship. If we read right from exhibit 5 in
No.
the certificate.
You see, this examination is here at page
That is deposition, Lordship.
deposition.
Yes, that is at
Page 54 is the
33.
type copy. The SMS version is at page 57. The school administration, the date of birth column is blank, full signature of father or guardian against the administration register, the age is given as so, but the remark column remains blank.
Today, I have brought the school register of our school from the year 77 to 80. In the said school admission register on dated 30/4/1997 at serial number 69. The name of Ahmed Ali, son of Jonab Ali, resident of so is recorded in the admission register of class 4. In the school admission register, the age is shown as 13 years, 8 months, 0 days as on 31/3/1978, page 55, Lordship.
Yes.
And it is mentioned that he had studied up to class 5. Exhibit A is the admission book. Exhibit A1 is the relevant page where the name of Ahmed Ali is mentioned, and Exhibit A2 is the serial number containing the same. On the cross, Lordship, on which date the Exhibit 5 was issued is not mentioned. Not mentioned, Lordship. Here, my friend says in 83, but he says not mentioned. In the Exhibit A, there is no seal and signature. In the school admission register, the date of birth column is blank. In the school admission register, the date of birth column is blank. Full signature of father or guardian column against Ahmed Ali is blank. In the admission register of Ahmed Ali, the age is mentioned as 10 years, 8 months, 6
Just
days.
now. We will show you this. Show you this again. Page 104.
Yes, Lordship.
See, before 104, please come to page 57
57.
of the writ petition.
Yes, Lordship.
Yes. Now you can read both together. Here, second line, নাবতী বহিত জন্ম তাৰিখৰ
খালি হৈ আছে।
হ্যাঁ কিছুটা খালি হয়ে আছে একো লেখা নাই প্রসিডিংসের গাইডলাইন তদন্ত খালি হয়ে আছে আহমেদ আলীর নাম হতে তারিখৰ বয়স 10 বছর 8 মাহ 6 দিন। Now look at that register.
So one thing is matching, the names are not there. The full name or the signature of the father or guardian is not
That's
there.
okay.
That is matching, Lordship. And the overwriting in the thing, that is the discrepancy which in the deposition he has stated 13 years and in the cross it is 10 years.
No, you see the register. Here it is different.
Here it is 3477.
13:110.
13110 is, yes, Lordship.
Here it is in the deposition, it is written, it is 10 years, 8 months, 6 days.
Yes,
That is the discrepancy. The
exactly.
document,
That is what I was coming, 10 years, 8 months, 6 months.
that is not there in the document. Where is the date?
Where did this come from? That is what I was trying to search, Lordship. Where has this figure
Not
come
there,
from?
sir, wrong reading or wrong writing.
Yes. And in, Abhumit Pratik, no question, what is one of course, sir? What is the difference?
It is here, but in the deposition, cross page 57. Also, it is clear, Ahmed Ali নামভর্তির তারিখত বয়স 10 বছর 8 মাস 6 দিন করে কি নথির উপর ভিত্তি কৰি উল্লেখ কৰিছিল মন্তব্যৰ ওপৰত কোনো উল্লেখ নাই।
There are no remarks, no reasons, nothing.
But that date is not there. The question could not have come.
But these dates must have been mentioned, otherwise it would not have been here, Lordship. What happened in the trial court, we can only ascertain from the records.
See, having spent some time there, both of us, if in the evidence, somebody gives a date that the particular event happened on 1st January 2026. So the tribunal, when recording, the court is normally expected to be conscious of what they are writing.
Yes.
So if a cause of action arose on 1/1/2026,
26.
it will be aware of the fact and then write. Because at that point of time, this document was before the exhibit 5 was before the tribunal.
Tribunal.
Question is asked and then it is recorded. So this date has come from where? That is only for the tribunal to explain.
Because the date of birth has been fluctuating right from the starting in this
No,
case,
it's concerned.
this one.
He says 65 is the date of birth. That is matching with even with this school
Voter ID.
document and the and his projection of age of 53 or 54 in the 2018. It matches. Voters list do not match.
So one document has to be incorrect, Lordship. Now we have to ascertain which one. Either the school one is matching, Lordship, with, because when that certificate was given, on what basis it was given, that also tribunal, the headmaster has stated that he does not know on what basis it was that certificate was issued.
That it doesn't say.
In the opinion I read out, Lordship,
No, you see this. Please come to. Please come to page 54.
yes. 24 is the voter case, Lordship.
No, 54 is the English version. SMS is at page 56. You see, in this page 56, if you come, first thing is that so and so আমার বিদ্যালয়ের পৰা জারি কৰা প্ৰমাণপত্ৰ হয়. So therefore, he admits that it is issued by the school.
Agreed by whom, but
Page 56, third line. The document is admittedly executed by the state, school. And then he says that I know the person, photographer found by Act, Ukta Sohi. মই আজি বিদ্যালয়ৰ বিমান বিমান পঞ্চায়ত নামে লগত আহিছে আনিছো উক্ত নামভৰ্তি তাৰিখ 34/1997 তাৰিখৰ 57 নম্বৰ আহমেদ আলীৰ পিতা জনাব আলী বিভাগ দাস বৰালৰ নাম চতুৰ্থ শ্ৰেণীত নামজাৰি কৰা পঞ্জীয়ন হৈ আছে. He admits whatever is there in the certificate. Then the discrepancy starts. The school admission register, the age is shown as 13 years, 8.0 days.
yes.
That is contrary to record.
That is nothing. What is there in the agreed post? That yes, it is.
Yes. Cheta Tinda Regulation. Which page is the school certificate?
32.
Hmm?
32.
Because you see, Ms. Verma,
Yes, Lordship.
when we are exercising centralized jurisdiction, why should we go and venture to examine the document? It is for the tribunal to examine the document and tell us what it is that question was asked.
Hmm. Deposition. Deposition of DWC.
You see what happens to the rest of the evidence, we are not on that. The documents must be correct. Correctly interpreted and correctly inspected by the tribunal.
People don't register. People never go for it. This is not people never go there.
Can you have the original record?
Yes. So what I have seen, your lordship is right, madam. But it is the deposition of the madam DW3 where it is stated. It is not in cross, madam.
Not in cross.
Not in cross. So what he has stated, my lord,
Just send the record.
yes, the record does not reveal the same.
Okay. You are saying that it is in chief, so therefore it is his evidence.
Yes, it is his evidence.
No.
So in cross it is clarified, madam. আহমেদ আলী নামভৰ্তিৰ তাৰিখত বয়স 10 বছৰ 8 মাহ 6 দিন বুলি এই নথিৰ ওপৰত 50 কৰি উল্লেখ কৰিছে, মন্তব্যৰ ওপৰত কোনো কথা উল্লেখ নাই. Nothing is mentioned with regard to it.
Which document information they know. Madam, this is not law.
Okay, then we close the matter, we'll take a call. You have anything more to say?
Lordship, that's all.
Heard. I send them to the petition and close the public correspondence. Pursuant to order passed earlier, the records of the traveling is received. Accordingly, the matter was heard. The motion stage. Commissioners computer order is over.
Your Lordship, the only thing is that the discrepancy your Lordship is pointing out, your Lordship, the contradiction with regard to record and the depositions, but that has not been recorded in the opinion, your Lordship. In the impugned opinion, nothing has been said about that, your Lordship. And your Lordship, only the ground under which the document was discarded was that full signature of the guardian was not remain vacant, and that on the basis of which information, your Lordship, the age has been recorded, your Lordship. And your Lordship, even in the order, page 60, your Lordship, in the second paragraph and in the fourth paragraph, your Lordship, the opinion states that his age was 13 years, 8 months as on 31/3/1978. And again, your Lordship, it was stated that he is recorded as 10 years, 8 months, 6 days as on the date of admission, that is 34/1977.
We are reading which page?
Page 60, your Lordship.
60.
Yes, your Lordship. Second para, your Lordship, the learned tribunal held
Yes.
that,
13/8/10. 13 years, 8 months.
yes, your Lordship. In 78 and in 77, it is recorded as 10 years, 8 months, 6 days. Second and fourth paragraph. Yes.
For motion item 15.
May please, your Lordship. My Lord, this case, order was passed on 15/5/2020. Record has got to be gone.
Record is available.
My Lord,
Record is available.
yes, record is available. Here in this case, my Lord, the findings of the tribunal is that, my Lord, the linkage with the grandparents has not been proved, my Lord. Page 68, paragraph number 2.
Yes.
Page 68, paragraph 2, from last paragraph 2, last 3 lines. From exhibited voter list, the opposite party and his parent could not establish their linkage with the Josan Ali, son of Kador, and so wife of Josan Ali, whom the opposite party has stated to be his grandson. Now kindly see the document which has been exhibited. Parents was also examined in this case, my lord. And he has come to the witness box and produced the documents also. Here, the grandparents, first grandparent is Kado. Kado, Josan Ali is the son of Kado. Then father of the OP, Fazrul is the son of Josan Ali. And Shahidul Haq or Rahman is the opposite party. Annexer page 12 can listen. Page 12 is the voter list of 1956.
Where is your written statement?
Written statement is there. These are the exhibited documents. I have annexed, my lord. Written statement as page 42, no, not 42. 42 is the evidence. First, two written statement is there, my lord. One additional is there.
Yes.
First one is page 30.
So you see, the reason for asking is, you see, please come to page 30.
Yes.
This is the paragraph 2.
Yes, paragraph 2.
The third line, the registrar of birth and death issued a birth certificate in the name of the petitioner, right, so and so, date so and so. In the birth certificate, the name of the father of the opposite parties by mistake is recorded as Fazul Rahman instead of Fazul Sheikh.
Yes.
Now, when a child is born, who gives the information to the sub-registrar?
He was born in hospital.
I understand,
Yes.
but who gives the information to the registrar? Either the father or the hospital. So the child, newborn child, he will not go and tell his father's name.
No, he will.
So therefore, the father giving an information to the hospital, and hospital docket goes to the sub-registrar's office. So there the father.
What
declares-
sub-register? Birth and death register.
Okay, that's what my mistake, but is the registrar of births and deaths.
Yes,
Now they take it from the hospital docket.
hospital. Okay.
Correct. Now in the hospital docket, the name will be recorded by your father only. He writes the name of Fazilul Sheikh. And you say that, no, it's a mistake. He should have been Fazilul Rahman.
Actually, Fazlul Sheikh is the original name.
That we don't know, but here you say that it's a mistake.
Yes,
Now,
there
who
is
will say that? You see, in a lighter note, I'll tell you, the question which was explained to me by a person who was 96 years old then. I tell this story always. See, that A is the father of B. How does B know that?
My lord,
You see, I'm asking you a question. B says that A is my father. How does he know that?
my lord, evidence of Fazlul Sheikh can be seen.
That evidence will come later. You disown your father's name.
My lord, in the evidence of Fazlul Sheikh, my lord, this question was never asked that you are not the father of the opposite party.
Doesn't change anything.
That annexer, my lord, can you see page 59? Question which has been asked. Page 59.
Yes.
My name is Fazlul Sheikh. I am 42 years old. I work in so and so.
My paternal father's name is Josan Ali. My father died so and so. My mother name is so and so. She died about 6 years ago. Opposite party Shahidul Rahman is my son. My wife's name is Sabit so and so. I have 8 siblings, 6 brothers and 2 sisters. They are Shahidul Haq, Ansul, Munisul, Farida, Shahidul Haq, Zakir Hussain, Mamoni, Farida Khatun. We are 8 siblings, 8 brothers, 1 sister. They are Jairul Haq, so and so, so and so. My father had 5 siblings, 2 brothers, 3 sisters. They are Hussain Ali, Josan Ali, and I have not seen my paternal aunt. I, along with my family, resides in the same locality of village Devattar Hasdoa, Part 5, under Gulokganj PS. I was born in village Devattar Hasdoa, Part 5. I cast vote in Devattar Hasdoa, Part 5. I cannot remember when I first time casted vote. Today I have come to this tribunal to adduce evidence on behalf of my son, Shahidul Haq. And kindly see page 52. Page 52.
The actual, last paragraph,
Yes.
the actual and correct name of the deponent is Fazlul Sheikh. The deponent humbly states that both Fazlul Sheikh and Fazlul Rahman is same and one person. Now, having said that, can you say that recording of the name in document A as Fazlul Rahman is a mistake? You see, you take a
Yes,
plea that you are an alias. So
Same
if an alias is used, can it be said that
same person will be the same.
then it can't be a mistake?
Yes. But
Other name is wrong. It is wrongly recorded, so that's not an NN. Suppose I have
but
another
this
name.
statement has not been given by Fazlul Rahman or Fazlul Sheikh, madam.
Which one?
This DW2. He never said that that was wrong.
Yes, he said that para two,
That deponent begs to state that he is the father of opposite party. named
last
as-
2 lines, read last 2 lines.
Last
In
2
the
lines.
birth certificate, the name of recorded mistake as Fazlul Rahman
Mistake that
instead of Fazlul Sheikh.
instead of Fazlul Sheikh.
It is his statement.
His statement.
And then he says that I have an alias. If the father comes and says, I have an alias, can the son come and say that no, he does not have an alias? Name is mistake.
My lord, apart from that, DW3, who is the secretary of the village, of that panchayat village, he also deposed that this, he is the son of this Faizul Rahman or Faizul Sheikh. DW3. He is the official witness. Fazlul Rahman. Is it? Page 29, the voter list also reflects that Fazlul Rahman. Lordship,
You've seen that.
page 29.
Now, this is an attempt to salvage. Now you get it. That's why the father rightly said that he has two alias. But son says, no, it is false. Father has only one name. It's a mistake. But that demolishes your voters list.
Somewhere it is Fazlul Sheikh, somewhere in Fazlul Rahman. And both from the same village, same house number, all this thing.
No, there's something more. If you read this, come to page 45.
45.
Yes.
Yes.
Now referring to voters list of 2015, second part he says it is to be mentioned here that the name of dependent father's name is wrongly written as Fazl Sheikh instead of Fazlul Sheikh.
Fazlul Sheikh instead of Fazlul Sheikh.
Yes.
Yes.
But look at the document at page 27.
27.
Yes.
Fazlul Sheikh.
2015. Fazlul Sheikh.
Next, Fazlul Sheikh. Shahidul Haq, Fazlul Sheikh.
Okay. Fazl Sheikh.
Fazlul Sheikh. And in upper part, Fazlul Sheikh.
Fazlul Sheikh. Yes. Anything else?
So the finding which has been arrived at that linkage has not been proved. That finding, my submission is perverse, Manish. And so far with respect to the birth certificate is concerned, nothing has been discussed. It is of 1992, original birth certificate. And against father, mother and other family members, there was no coroner's case, madam. Or there is no doubt also. And father himself deposed before this tribunal that there was no case against them. And in the voter list also, the date of birth and birth certificate date of birth is matching, my lord. There is no discrepancy. Birth certificate. It is also matching, and the village name, all these things are matching. Devottar Hasda, part 5. Under Logan's LSC. And Panchayat Secretary also deposed that he is the,
Came as DW3.
my lord,
He came as DW3.
DW3, Panchayat Secretary. This is the official witness. To prove this certificate which has been issued. And in the reference also, my lord, there is no mention about that whether which territory he has come and whether there was any date of, because obviously he was born in 1993. '92, sorry, not 93, 92. 31/7/1992. What is it?
That's all.
92.
It is the document, 92 document are.
Probably.
We don't need.
I think,
Yes. Anything else?
My lord, the grandparents, the lead also proved, my lord. Produced as a document, my lord.
Shielded was post 71, I think,
Yes,
72.
76.
Hmm.
76. My lord, main question is that when the father was declared, neither has been doubted about their citizenship, then how can son be doubted?
Yes.
And there was no question was put that the opposite party is not the son of DW2.
On what basis we are saying that the father is an Indian citizen? That no proceeding is against?
No proceeding, and he has produced the documents of his own regarding the voter list from father's father, then grandfather voter list also produced from 1966 onwards. And it is from the same village.
Is relying on any case law?
Regarding discrepancy, my lord, case law, one judgment, my lord, recently passed on 13/7/2026 only by the Supreme Court in Civil Appeal number 2820 of 24.
Yeah.
Yes.
We are from other ex parte and.
Not only ex parte, there are three sets of one ex parte, one is meets of the evidence left, and another is evidence was late. Three types of cases has been dealt.
Ex parte and then order passed by the High Court. In WPC. Three situations.
Three situations.
Yes.
And regarding exhibit O, there is one exhibit, exhibit O, residence certificate. That is also proved.
What certificate?
Exhibit O,
Oh,
resident.
residency certificate. Residency certificate on standalone, it won't be sufficient. It has to be used with others, right? On its own, it may not be sufficient. The residency certificate. Issued by?
By the Panchayat secretary, Panchayat, government official. And secretary has come and proved it. Dev GP.
Yeah, 1944. Because it was a compound. Yes, Mr. Fine.
May I please, ma'am? Well, first of all, your lordship may kindly see as your lordship has rightly pointed out, the sole certificate document by which the petitioner is trying to link himself to the projected further manner, there is the birth certificate. And birth certificate, as your lordship has rightly pointed out, in para 2 of the WS, as well as the evidence of DW2, it is said, para 2, it is clearly said, in the birth certificate, the name of the father of opposite party is recorded by mistake as Fazilur Rahman. And what my submission is, it is in the birth certificate only where the name of Fazilur Rahman is recorded. Now, if your lordship may kindly see the voter list, that annexed by the petitioner here, from the first voter list of the projected further is 1989 project. This is page 19, my lord. 1999 voter list, page 18 and 19. In this document, the father name, the projected father is Fazlul Sheikh. So in 1989, the father name is shown to be Fazlul Sheikh. And then my lord, page 22, and operative person, page 23.
21.
21. 21 is 89. Yes. Then 97 it is Fazlul Sheikh again. Then my lord, 2005 it is Fazlul Sheikh again. Then 2010, my lord, page 25 it is Fazlul Sheikh again. Then 2015 it is Fazlul Sheikh. And 2019, my lord, it is Fazlul Sheikh. So Rahman is nowhere. Rahman is seen only in the birth certificate. And it is not that in 1989, it was Fazlur Rahman. Even in 1989 also, he is identified himself as Fazlul Sheikh. So suddenly the birth certificate only, which is relied by the petitioner, the name is Fazlur Rahman. And he has stated that is the wrong name. Now another aspect, madam, if your lordship may kindly see the position of the question put by the tribunal, madam, page 59. Because if we see, madam, the evidence filed by DW2, page 52 and page 59. Page 52, he is saying Fazlul Sheikh alias Fazlur Rahman alias Fazlur Sheikh. Is it about 54 years? Then in page 59 also, in the top, my lord, my name is Fazlul Sheikh alias Fazlur Rahman, Fazlul Sheikh. Is it about 54 years? But interestingly, when he was questioned, my lord, what he said, my name is Fazlul Sheikh. I'm 42 years old. How can he say, my lord, the same person he is contradicting himself? Now in the next part, my lord, I work at so-and-so. My parents' father's name is so-and-so. My parental father's name is Josen Ali. My father died about 10 years ago. This is very interesting because this was deposed in 2000 on my lord. This is on 2019. So father should be there. And if the father died prior to 10 years back, my lord, 2009, 2008, 2007, 2006, somewhere father should have been there. But if documents, my lord, produced by the petitioner, the father and grandfather is not together in any document, my lord. If your lordship may kindly consider the voter list. Up
Just
to-
a moment, just a moment. Yes,
If your lordship may kindly see, is the petitioner's father's name, the DW2, his name is appearing in the voter list from 1989 onwards. If your lordship may kindly see page 19, my lord. This is the first voter list where presented father is appearing.
page number 39.
1919, starting from 18. It is 1989.
For the rule.
Yes. Fazlul Sheikh, Kasu Sheikh, and Romia Sheikh. These are the persons whose names are enrolled in the voter list in 1989. But his father name is, the grandfather is not there as a voter. And if your lordship may see previous page 17, this is the voter list of 1977, where the projected grandfather is there, Josen Ali Sheikh. And other sets of persons, my lord, Josen Ali Sheikh, Zori Khan Bibi, Hassan Ali, Hamid Bibi. These are the persons who were continued till 1977. After this, from 1989, there is a different set of people whose names are, who has no link or who are not common voter in any voter list. So first of all, the petitioner has to establish, my lord, that his father is a citizen of India. because that is the mandate as per the Sovereign one. To establish his father as a citizen of India, either he must have some documents to show that he was there prior to 1971 in India, the petitioner's father, or he has to link himself to his projected grandfather, father of the petitioner. Now, there is no document to say that the projected father and grandfather has any link, because why I have stated, I have shown the evidence, statement given by the evidence given by the DW2. He has stated father died just 10 years back in 2019. So father should have been alive till 2009, at least 2008-9. So why not the father and other family members, other voters whose names were there in 1971, 72, 77, are not there after 1989. So these are not there. So link between the father and the grandfather is not there, has not been established. Now, second thing, if father and grandfather could not be established, the petitioner, because petitioner has to establish his link to the grandfather, because father has no document prior to 1971. So if that link is missing, the petitioner could not establish his link. Apart from that birth certificate defects in the birth certificate cannot be accepted because it is the birth certificate is the base document, nearest document of the petitioner, which show that he is the son of some Fazlur Rahman. That could have been the best document if the name was correctly met as Fazlur said. But in that certificate itself,
There is a problem. Yes.
Now, another issue, my other senior friend has argued that point, that here the Panchayat certificate has to be accepted. But in fact, the Panchayat certificate, the Supreme Court in Ramjan Begum, it has clearly said that the Panchayat certificate initially this Honorable Court rejected for the purpose of NRC. The Panchayat certificate cannot be used as a piece of evidence to go his lineage or her lineage. And Ramjan Begum, 2018 1 SCC 579. This point has to be cleared, 2018 1 SCC 579. It is clearly said, para 15, 15 and 16. My point there is, the Panchayat certificate was allowed for the limited purpose for linking one person to the another. Whom these are allowed, the exercise in the para 15 seat certificate issued by the GP's secretary merely acknowledges the shifting of residence of a married woman. This has to be written. This is only for married women. And to acknowledge the shifting of residence of a married, acknowledge the shifting of residence from one village to another. This certificate has a limited purpose. The said certificate by itself by no means establishes any claim of citizenship of holder of this certificate. That is also true. However, it can be used, my lord, in para 16, later on it is said. However, the certificate issued by the GCC by no means a proof of citizenship. So first of all, my lord, it can be used by the only married woman. Secondly, to acknowledge the shifting of his residence after marriage. Only for that purpose, my lord, GP certificates were allowed. And for that purpose also, the Honorable Supreme Court has said, the certificate issued by the GP certificate by no means a proof of citizenship. Thus, proof will come only if the link between the claimant and the legacy person who has been a citizen is established. So he has to establish that their father is a citizen. Then only the link can be. The certificate has to be verified at 2 stages. These 2 stages has to be complied with. The first is the authenticity of the certificate itself, and the second is the authenticity of the contents thereof. That is already argued in numbers of cases. The latter process of verification is bound to be an exhaustive process, in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. It is the petitioner who has to establish that it was after due process, exhaustive process, the entire materials which were entered in the certificate is recorded. So my submission is a male person cannot take benefit of any consent certificate. This is only for married women to establish his link between his father and to acknowledge his shifting from one place to her shifting from one place to another. So even though consent certificate, I'm not disputing whatever there is, I'm not on merit matter, but even though some consent certificate is submitted, that can be allowed only for married women, and then it can be looked into. So for this purpose, what I have submitted already, the petitioner, the tribunal has rightly declared the petitioner to be foreigner in absence of any linkage documents to the petition, to the projected grandfather. I'm not saying father, to the grandfather. That's it.
One reply, my lord, page 29. Page 27 and 29.
Yes.
Page 29, Fazlul Sheikh, Hasan Ali. Then Shahida Bibi, Fazlul Sheikh. Then Shahidul Haq, Fazlul Rahman. He is the son. Then daughter Farida Khatun also Fazlul Rahman. Then Shahidul Haq. This is the link of Fazlul. Because sometimes they are written in Sheikh, sometimes written in Rahman. In earlier 27 also, Fazlul Sheikh, Hasan Ali. Saida Bibi, Fazlul Sheikh. Shahidul Haq, Fazlul Sheikh. Not correctly mentioned. Then page 25 also, Fazlul Sheikh, Hasan Ali. Saida Bibi, Fazlul Sheikh. Then with regard to these are the grandparent document. And another document, page 17, is the father of the grandparents.
Page number?
17. Not 17, page 13. It is from Kodo Sheikh. Kodo Sheikh, then Hasan Ali, then Fazlul, then Shahidul. 4th generation. Much.
Let's get Ghosh and counsel for the petitioner and so for the respondents. Pursuant to order passed earlier, the records of the tribunal is received. Accordingly, the matter has been heard at the motion stage. Next, judgment is.
Item 17.
They'll have to wrap it up early. They're not getting anything. We just it after 3 weeks. In the meantime, they are continuing with the investigation, but nothing has come out.
Yes, Your Lordship, yes. This is simple, this is already in record, Your Lordship, basically.
Not already.
Further investigation is required, Your Lordship.
It's going on.
It's going on last page, presently pending for the further investigation.
But which one?
MH Ali, Your Lordship.
MA,
MH Ali.
MS Ali, Learning Council, the petitioner. P. Sharma, an additional senior government advocate for the respondent numbers 1 to 5. For Ms. Kataki, you are appearing in this matter? No. By the motion, then would be there, you would be there. Oh, no, you are not there. Election Commission is not there. We made a mistake in the earlier order. Okay. P. Sharma and senior government advocate for respondents 1 to 5. Next, for it may be stated that no notice has been issued on the respondent number 6 till date. Next paragraph. Pursuant to order passed on 17/6/2026, from the learned additional senior government advocate has produced a copy of status report of the investigation, which reveals that so far as investigation made till date, no circumstantial evidence has been collected yet. However, the IO is trying his best to come to a conclusion on the basis of circumstantial evidence. And the matter is presently pending for further investigation. I mean, they said status report is retained as a part of record. Next para. As it is projected that the further investigation is pending, the matter is adjourned today. Let's talk to date after 3 weeks.
Lordship, a copy of the report may be given.
No, these are confidential. Whatever is required, we already mentioned in the order. But these details cannot be given. I think it's because seeking some time. And like more, the period and all those things are there, which may not be to disclose it right now. List on.
Item 18.
May I please?
And it in order on page 109, my lord, whereby the petitioner declared foreigner, my lord, post 1971, my lord. My lord,
109.
yes, my lord, order dated 28/11/2025, my lord.
Yes, we are doing it. Doing it. Mr. K. M. Hassel, counsel for the petitioner, and so also for the respondents. Impugn order is at page 109, dated 28/11/2025, passed by so and so in case number so and so, by which the and IMDT case number so and so. It is in the middle of the paragraph. By which the petitioner was declared to be a foreigner post 2021. Notice reserving for weeks, extra copies also the records. 10 days time to take bail of ₹5,000 to be satisfaction of superintendent of police member. Which place? Corbetta.
Yeah, Bodali, my lord.
Bojali. Extra copies.
I have within how many days?
10 days.
My lord, yeah. Problem, my lord.
Item 19.
Yes.
The include order, my lord, that is annexed to page 15. And date, my lord, 21/22/11/21. And the regular expert order, the regular university guidelines annexed 3, page 17.
But here your father was served with the notice. He gave a common impression.
My lord,
Here the notice was served on your father.
yes, it is happened, my lord.
Then
Actually, my lord, he was not at home. He resides in another district, my lord.
that will give you benefit. Even if there's this order of the Supreme Court in Savitri Day, it doesn't give you benefit.
He was also informed, my lord. So, my lord, the tribunal passed the information. And I have given notice, my lord, notice to be then, notice is issued and the report, my lord, survey report, that is annexed to, my lord, page 15. Someone was issued and it was served on my father. Father received the same by his thumb signature, but that was not informed to me. I received
There
it
is something
also.
between you and your father.
Father received it, yes. There is admitted and there is no dispute. And he came to know about this order when in this general election 2026 came. And his name was not there in the voter list. So he starts the same from the local BLO. And BLO gave him the number, etc. Then he find out everything and all these things, and obtain copy, etc. and come to court. So, and on merit Willard, there is a merit Willard, my submission Willard, merit is there for him.
You are not inclined. Sir, some very belated. Okay. Same thing, we are fixing it on third. You make your response by them. Mr. A. Rashid, learned for the petitioner and so also for the respondents. Matters with similar issues have been posted on 3/8/2026. Accordingly, issue notice returnable on 3/8/2026. Extra copies we served on the learned State and Department Council within 2 working days. Next, list on 3/8/2026. Thinking of all those matters together.
Item 20.
Yes, please, your lordships. Lordship, it is a contested case. The impugning opinion is at page number 28, lordship.
28,
28.
725. Okay, here also give Dale. Mr. S. Dale and counsel for the petitioner, and so also for the respondents. Opinion is at page 28, dated 37/2025, passed by so and so in so and so, so and so. By which the petitioner declared to be a foreigner post 25/3/71. Notice extra copies out for the records. The 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Gwalpara.
Much obliged.
Item 21.
May I please, Lordship. Lordship, expert order.
Page
Lordship, 53. Notice was served by hanging with fair price shop, Lordship. Page 40 is the service report, Lordship.
Where is the opinion page?
Page 53, Lordship.
53.
53, 5.
But this is a part of your residence. This address. Come to page 40.
Yes, Lordship. Page 40, village Tapasara, same village, Lordship. But service report says that I was not there, Lordship. And notice was served by hanging with fair price shop.
Mr. Payne, then there is a variation in this, what do you call?
Ordered in deposition of.
No, page 40, this, personal writing at page 42 is very difficult to read. So here in page 40, I am reading the, translated copy. Notice was served by hanging with the fair price shop of so and so village. Correct. Now in the order, page 53.
Yes, ma'am.
Here it says it's a part of the house, office residence. Para 2. Notice is served by hanging at a copy of the fair price shop near the house of so and so, which is a conspicuous part of office residence. These two are in variance. Page 40 and 40 and 53.
Yes.
41. 42.
Page 52, probably on the basis of this, the
No, we understand, but the tribunal does not go there.
No, no,
You
that,
have to arrive at a finding on the
On the
basis of
basis
some
of-
material.
some matters. Well, page 52, my lord, he is stated, probably for that reason it is said, my lord. I am present today in the summons of tribunal presently, and this is the, my lord, process server who served the notice, my lord. Above mentioned address, right, in the middle portion, my lord. Upon Mustafa Bibi so-and-so, only found that OP is not available in the given address, and hence the process server hang the second copy of the notice at a fair price of located at the last address of the OP in presence
No,
of
please read this page 42. I have not been able to read this.
42 is, my lord, not
May I read? Lordship?
exactly in connection,
Please
exactly,
Yes, yes.
yes.
Read it.
Page 42.
Second paragraph.
Yes, Lordship. Second paragraph. সেয়েহে জাননীৰ মূল কপিখনত উক্ত গাঁৱৰ এজন নিৰপেক্ষ ব্যক্তিৰ সাক্ষী হিচাপে চহী লৈ জাননীৰ নকল কপিখন হাপাচৰা গাঁৱৰ সুলভ মূল্যৰ দোকানত লটকাই জাৰি কৰি মূল কপিখন মহামান্য আদালতলৈ পঠিয়াই দিয়া হ'ল।
Yes.
Yes, Lordship.
Correct. Now, this evidence you see at page 51. Second copy of the notice at a fair price shop at the address given in the so-and-so in presence of so-and-so. So here also, it says the same thing.
Yes, fair price shop located at the address.
Correct.
Yes.
But look at the order. Fair price shop near the house of the OP, which is a conspicuous part of the OP's residence. This is,
Yes,
it is
that
not
is
there.
not, yes. But page 52, my lord, this is another process server. Here it is some extent said, my lord, not available at the given address, and hence the process server hang the second copy of the notice at fair price shop located at the last address of the OP in presence of one witness so and so.
So located at the, you
That
see,
is misinterpreted probably, my lord. Located at the,
so notice issued by someone to High Court cannot be given at the flower shop outside the High Court
High Court, my lord.
wall.
This can be, this can be done by voice.
It passed orders in chamber because there is a single bench for my esteemed brother. We are sending this back.
Yes,
Dictate orders in the chamber. There was one prayer for upgradation. We'll get it listed tomorrow. So today we can't take up. Which item was that? 25. You take it up tomorrow then. 25, because there is some agency express in the matter. Will accordingly list the matter on visit. Take it tomorrow. Oh, what is it? Yes, Mr. Saiki.
Well,
Yes.
item number 43 will be taken up, my lord, day after tomorrow. There is some urgency, my lord.
Lordship, I have a
No,
prayer.
it goes, item 43,
Yes, my lord.
just a moment.
I am for the respondent, my lord.
Lordship, Mr. Mazumdar sir will appear in this case, Lordship. His brother is ill, Lordship. Today suddenly admitted to the hospital, Lordship. So it matter maybe early fixed on 30, Lordship.
Yes, no problem. I did not know actually. Let it be on 30.
As it was spelled.
How about, I don't know.
Oh, okay.
Please try, no?
42.
Please try, difference.
When do you want the matter to be listed?
On 30, Lordship.
30.
30, Lordship.
That will be too long.
Lordship, his brother is admitted for heart attack, Lordship.
Oh, okay.
He is not.
Mr. Mazumdar is there, Mr. Dev Mazumdar.
Delhi Mazumdar sir's brother.
Please inform Mr. Fukarna if we are not getting it. Is there? Okay. All sides are duly represented. If one counsel for the applicant requests a video conferencing board. Next para. It is submitted that It is submitted by Ms. R. Barova that the learned additional advocate general had to leave early as his brother is indisposed. Accordingly, matters stand adjourned today. List on 30/7/2026. Mr. Segia, we have to adjourn then.
The petitioner who wants that to be agreed that we have no objection. Some petitioners want that to be agreed in this case. We have no objection.
Substitution petition, I will have to file, your lordship.
Pawan Kumar.
But
For-
tomorrow I'll file.
In respect of,
Respond number 19.
that is not on record.
Not on record. We have filed it, it will be on record on the next day.
Take it on record.
Yes, your lordship.
Your Lordship, I beg to appear in item 43,
Yes, you have recorded your presence.
obliged.
Matter has to be adjourned today because the additional advocate general's brother is ill.
No difficulty. Lord, any date if your Lordship can fix subject to convenience?
You fixed it on 30/30.
Obliged, your Lord.
All right.
Yes,